Good day everyone. My name is Sri Lashmi Krishnan and I'm the group leader for this presentation together with my group members from tutorial 2. And today we will be analyzing a problem question for Contract Law 1 which involves 5 different contractual situations concerning the character Ida who's a nurse. Each group members will be responsible for each situation and we will identify the relevant contractual issues arising from the facts. The first situation will be presented by Mr. Mahesan, which concerns the advertisement made by Cepat Sehat Sendirian Berhad that had affected Ida. Meanwhile, the second situation will be presented by me, which involves an agreement made between Ida's father and his close friend in relation to a wedding gift. Then, the third situation will be presented by Mr. Rafiq, which relates to a promise made within a family arrangement between Ida and her mother. And the fourth situation will be presented by Mr. Tai Lizwan, which concerns Ida's scholarship bond with the Ministry of Health. The fifth and the final situation will be presented by Mr. Akram, which involves a house purchase transaction between Ida and a property agent. I will now gladly pass the presentation to Mr. Mahesan, who will be explaining situation 1 of the question.
The issue is that whether the advertisement by Cepat Sehat Sendirian Berhad constitute a legally binding unilateral contract which entitles Ida to claim the 10,000 ringgit reward after she suffered a serious allergic rash reaction despite complying with the instruction laid down by Cepat Sehat Sendirian Berhad. The application of the law. The advertisement was clear, specific and conditional. Ida fully complied with the stated condition laid down by Cepat Sehat Sendirian Berhad. She suffered the very harm the product claimed by Cepat Sehat to prevent. Acceptance occurred through performance under Section 8 of the Contracts Act 1950. There was valid consideration which exists under Section 2 Sub D of the Contracts Act 1950. The intention is presumed due to the certainty of the reward which was offered by Cepat Sehat Sendirian Berhad. Cepat Sehat's refusal is inconsistent with established principles of unilateral contracts. In conclusion, a legally binding unilateral contract exists between Ida and Cepat Sehat Sendirian Berhad. Cepat Sehat is therefore liable to pay Ringgit Malaysia 10,000 to Ida. Ida has got a higher chance based on the sections in Contracts Act 1950 and supported by the hallmark case of Khalil versus Carbolic Smoke Ball Company to win her suit. Thank you.
Thanks again, Mr. Mahesan. Let me begin with the material facts of the situation too. So, Ida's father Rahman had entered into an agreement with his close friend Johan. So they both agreed that if their children Ida and Johan's son Afiz married each other, each father would give them 50,000 Malaysian ringgit to the couple as a wedding gift. So when the marriage took place, Rahman fulfilled his promise. But unfortunately, Johan died before making the payment. So Hafiz and Ida tried to claim the 50,000 Malaysian ringgit from Johan's estate, but Johan's executor refused, arguing that they were not the parties to the contract. Therefore, the central legal issue here is whether Ida and Hafiz, as third-party beneficiaries to an agreement between their fathers, who are Rahman and Johan, have the legal standing to enforce the contract against Johan's estate. The central issue here also includes four main key facts, which are the agreement, performance, breach and the party's status. As for the agreement, Rahman and Johan made a mutual promise to give 50,000 ringgit each to Aida and Hafiz upon their marriage. Meanwhile, for the performance, the marriage is occurred and Rahman fulfilled his obligation. And for the breach, Johan died before paying his share and his executor refused the couple's claim on the grounds of the privity of contract doctrine. The last but not least is the party's status. Aida and Hafiz are strangers to the contract itself, even though they are the intended beneficiaries. Next, we will be moving on to the application. The general rule here is the privity of contract under Malaysian law, which follows English common law principles. So the doctrine of privity of contract dictates that only those who are parties to a contract can sue or be sued upon it. A contract cannot generally confer rights or impose obligations on a third party. This is also referred in the case of Kepong Prospecting Ltd and others and Schmidt. In this case, the federal court confirmed that this doctrine applies in Malaysia, meaning third party cannot enforce a contract even if it was clearly intended for their benefit. Therefore, Aida and Hafiz face a significant legal hurdle because they did not personally bargain with Johan or Rahman. The facts of this scenario are almost identical to the classic English case of Tweddle and Atkinson in the 1861. In this case, the fathers of a bride and groom agreed in writing to pay the groom a sum of money. So when one father died without paying, the groom sued the executor. The court held that the groom could not sue because he was not a party to the contract and had provided no consideration. So due to this case, we can actually connect two sections from the Contract Act 1950 to this scenario, which are Section 2D and Section 38 subsection 2. Here's how Section 2D and Section 38 subsection 2 of the Contracts Act 1950 involved in this issue. So first of all, Section 2D of the Contracts Act 1950 allows consideration to move from a third party, which is a departure from English law. The separate hurdle of privity remains and the person suing must still be a party to the agreement. Meanwhile, the liability of the executor under Section 38 subsection 2 of the Contracts Act 1950, promises generally bind the representative of the promisers in the event of their death. Therefore, Johan's estate is technically liable for the debt Rahman and Johan contracted. However, the executor's argument is based on who has the right to demand the money. Other than that, the parties of this issue also has different perspectives. Firstly, Aida and Hafiz. They will argue that the contract was specifically for their benefit and that Rahman has already performed his part, making it unjust for Johan's estate to withhold the gift. So they might attempt to rely on trust exemptions, which is shown in cases like Malaysian Australian Finance and the Law Union and Rock Insurance Co. Ltd. In this case, the courts have allowed a third party to sue if the contract can be construed as a trust created in their favour. And based on Johan's executor's perspective, the executor is relying on a strict interpretation of privity, and this is referred in the case of Tweddle and Atkinson and Kepong Prospecting, where they are currently on strong legal ground to refuse a direct claim from the couple. And lastly is the perspective of Rahman, who is the promisee. As a direct party to the contract, Rahman has provided executed consideration by paying his 50,000 Malaysian ringgit. Unlike his children, Rahman has undisputed right to sue Johan's estate for a breach of contract. Based on my research, we can come to a conclusion. So in my opinion, Aida and Hafiz are only third-party beneficiaries but are not the contracting parties. So therefore, they may struggle to sue their personal capacity due to the doctrine of privity, which is shown in the case of Tweddle and Atkinson. So therefore, the contract itself remains valid and binding on Johan's estate under Section 38 subsection 2 of the Contracts Act. From my conclusion, I can advise Aida and Hafiz that a direct suit against the executor is risky and likely to be dismissed for lack of privity following Kepong prospecting. However, they could potentially argue that the agreement created a trust of the promisee for their benefit, which is an established exception to the privity rule. Moreover, I can also give advice to Rahman. This is because Rahman is in the strongest legal position and he should be advised to bring the action against Johan's estate himself. So as a contracting party who has performed his obligations, he can seek specific performance of Johan's promise or damages for breach. Following the logic in Beswick and Beswick case, even if a beneficiary cannot sue personally, the other contracting party, who's Rahman, can sue to ensure the estate fulfills the promise made to the third party. Finally, I can also give advice to the executor. This is because while the privity defense is a valid preliminary objection, the executor should be cautioned that the estate remains bound by Johan's promise to Rahman. So if Rahman sues, the estate will likely to be ordered to pay the Rm50,000, as there's no contrary intention in the facts to suggest the death of the promisor was meant to revoke this specific wedding gift obligation. So that's the end of my part, and from now on, Mr. Rafiq will take over the presentation. Thank you.
Hi, my name is Muhammad Rafiq Q, and I will be explaining the situation number 3. So the situation number 3 goes like this. Later, Ida, who was struggling financially, accepted her mother's offer to leave her nursing job and study law full-time. Her mother promised to provide her a monthly allowance of 2,000 ringgit until she graduated. After 1 year, disagreements arose between them and her mother stopped paying, insisting that family arrangements are not contract. So the matter of facts here is Ida was struggling financially from the nursing job she had. And then she accepted her mother's offer to leave her nursing job and study law full time. Her mother promised to give to her a monthly allowance of 2,000 ringgit until she graduated. After 1 year, this disagreement arose between them, and her mother stopped paying and insisted that the family arrangement are not contracts. So we take a look at the issues. So the issue arose between the mother, Ida's mother, and Ida is first, we need to take a look whether the promise made by Ida's mother constitute a legally binding contract under the Contract Act 1950. And then the second issue is whether the promise made by Ida's mother falls within the Section 26, subsection A of the Contract Act 1950 as an agreement made out of natural love and affection, whether the relationship between Ida and her mother satisfied the requirement of near relation under the Section 26, subsection A, Contract Act 1950. And lastly, the issue that can be seen here is whether Ida act of pursuing study was done voluntarily as per se in Section 26, subsection B. So the relevant statute that will be suited in this situation, it will be Section 26, subsection A, Contract Act 1950. So what does Section 26 says about this? So Section 26 says that an agreement made without consideration is void unless it is in writing and registered. It is expressed in writing and registered under the law, if any, for time being enforced for the registration of such document, and is made on account of natural love and affection between parties standing in near relation to each other. So Section 36 basically explains it is made on account of natural love and affection. The agreement is in writing, properly registered under the relevant law, and is made out of natural love and affection between parties who are closely related together. Still, on the exception of the consideration or any agreement made without the consideration is void unless, so it's an exception, is we can take a look at the Section 26, subsection B, Contract Act 1950, whereby it goes like this: or is a promise to compensate for something done. It is a promise to compensate wholly or in part a person who has already voluntarily done something for the promisor, or something which the promisor was legally compellable to do. It is a promise to compensate wholly or in part a person who has already voluntarily done something for the promisor, or something which is the promisor was legally compellable to do. Meaning that if the act was done voluntarily, which is expressly. So therefore, the consideration is not void. So the relevant case law that can be seen for the subsection, for the section 26 subsection A, is in the case of Ri Tan So Sim and Chan Lain Kyong and others, and Tan Song Kiao and others, which is the Taylor judge stated that it is impossible to define relationship or nearness without either extending or restricting the legislation, which would be beyond the province of the court. If the word near were omitted, then the most of distant cousin would be an eligible relation and the clause would be unmanageable. So the word relation and near must be applied and interpreted in each case according to the modes of the group to which the parties belong and with regard to the circumstances of the family. So for the cases that is for the section and the exception that falls under 26B, we should take a look at the case decided cases, which is Waterspoon and Henry Agency House. In this case, Sufyan Justice stated that in this case, the plaintiff had done what he did at the suggestion of the defendant firm without any agreement by the defendant firm to pay any remuneration. Was such act done voluntarily? Given the word voluntarily is ordinary everyday meaning, I am the opinion, Sufyan Justice said that he is in the opinion that the act done by the plaintiff for the defendant firm at the latter suggestion had not been done voluntarily, and therefore the promise made without consideration by the defendant firm uh, is not part of the contract. So therefore, Witherspoon give the actual meaning of the what is done voluntarily. So in this case, the plaintiff does not succeed in his NILA claim. Yeah. So for the cases that have been given, and also from the statute that has been given under the Contract Act 1950, we can say that Ida and her mother are closely related by blood, satisfying the requirement of near relation. The promise of monthly allowance was made within a family context, suggesting it was motivated by natural love and affection. However, there was no written agreement between Ida and her mother. The arrangement was not registered under any relevant law. Based on the Ritan Sosim and Chan Lai Kong and others, and Tan So Kyo, the court assessed near relation contextually, but formal statutory requirements cannot be ignored. While the relations satisfy the near relation element in 26, section 36, subsection A, requires strict compliance with writing and registered. So now we take a look either the agreement without consideration void unless, which is the exception under 36 subsection B, is falls between the situation that arose between Ida's mother and also Ida. So the mother promised provide 2,000 ringgit monthly before Ida resigned and commenced her law studies. Ida resignation from her nursing job was done in reliance on the promise, not before it. Therefore, Ida did not perform any act prior to the promise. The promise was not made to compensate for a past act, but to induce future conduct. Applying Witherspoon and Henry Agency House, an act done at the suggestion of the promisor is not considered voluntarily. Ida left a job at the mother request, meaning that her act was not voluntarily within the meaning of the section 26 subsection B. Additionally, the mother was not legally compelled to support Ida financially. So now we take a look either the agreement without consideration void unless, which is the exception under 36 subsection B, is falls between the situation that arose between Ida's mother and also Ida. To summarize up all of these cases that has been arise between the Idas and also Idas. So the promise made by Ida's mother does not fall within the section 26 subsection A of the Contract Act 1950, although the promise was made between close family members and may have arisen from their natural love and affection. The agreement was not in writing, and also the agreement is not registered. Therefore, the statutory requirements under the section 26 subsection A are still not satisfied. Therefore, it will not fall under the exception. The promise also does not fall within the exception under section 26 subsection B because of the Contract Act 1950. So because of the Ida resigned from her job and because of the promise, not before it. So because of the promise was made to compensate for a past act, was not made to compensate for the past act, rather than induce for something that is going to happen in the future. So her act was not at the suggestion of the promisor, and therefore it was not a voluntary act within the meaning of section 26 subsection B. That is consistent with the principle in the case of Waterspoon and Co Limited and Henry Agency House, which is as a result, no valid contract can be established under the exception in the section 26A and section 26B. Therefore, the promise is not enforceable under the statutory contract law. So that's all for me. Thank you.
The next situation will be on the topic of scholarship. So let's have a look at some of the issues. First of all, Ida joined the Ministry of Health, MOH, under a 5-year government scholarship bond. Now, 2 years later, she resigned to work overseas. The government demanded that she should repay the entire bond amount, but Ida argued the terms of the scholarship were unfair and thus constituted a penalty. So, what are the questions of law that we need to address? First of all, whether Contracts Amendment Act overrides the Contracts Act in terms of scholarship agreement, whether someone is entitled to a reduction of payment based on a partial completion, and thirdly, the issue of the absence of consideration. So let's have a look in what a scholarship agreement actually is. So under the Contracts Amendment Act 1976, a scholarship agreement is any contract or agreement between an appropriate authority and any person with respect to any sort of scholarship. So what is an appropriate authority? An appropriate authority means the federal government and also some other institutions. The Ministry of Health, MOH, is a part of the federal government, thus is an appropriate authority. That means that under the Contracts Amendment Act, the scholarship agreement between IDA and the government is valid. So let's have a look at the Contracts Act actually. In Section 26 of the Contracts Act, all agreements must have consideration, but there are exceptions. We look into CAA, subsections for A and C. In 4A, it states that agreements are valid even if the scholar was a minor. And in C, it states that no scholarship agreement shall be invalidated on the ground that it lacks consideration. Now, what does it mean? It means that either can't say that, oh, because I'm a minor or because there's no consideration, thus the scholarship agreement is invalid. It doesn't work. Now, let's look at how the remedies should be addressed. So we look into Section 5 of CAA 1976. In subsection 5A, it states that if in a case of a breach, the scholar is liable to pay the whole sum. And the statute further specifies that the sum is payable whether or not any sort of damage or loss has been caused. And most importantly and crucially, Section 5A explicitly mandates that no deductions can be made for partial service. Thus, this is really, really bad news for IDA. Now, remember the penalty argument she brought up, which is relying on Section 75, which states that only reasonable compensation should be awarded. But if you look into subsection 5A of the Contracts Act, of the Contracts Amendment Act, it states that notwithstanding anything in the Principal Act, that means anything that is within the Principal Contracts Act doesn't matter because CAA takes precedence over the CA. Thus, the penalty argument doesn't work. Now, Malaysian courts have consistently upheld these rigorous terms. In the case of University of Malaya and Lee Ming Chang, the scholar had to pay the full agreed sum despite serving 2.5 years of a 5-year bond. It doesn't work. So, in the case of Government of Malaysia and Gurcharan Singh, the government also held that education is classified as necessaries. Now, what are the perspective of the parties? Now, Ida might argue that, oh, she has done 2 years, and the agreement was harsh and burdensome, as in the case of De Francisco and Barnum. But it doesn't work because there's a specific act called the CAA 1976. She could also argue in the case of Icon City, which is on the issue of whether the agreement or contract is clear. But if we look into the perspective of the government instead, the government can rely strictly on Section 5A of the CAA as it grants them the full name sum regardless of any partial completion of service. Whereas the doctrine or rule of contra preferentum from Icon City only applies if the clause in the agreement is ambiguous. But in this case, the CAA 1976 clarifies that partial completion doesn't count. Thus, there is no ambiguity as seen in the case of Icon City. So, in conclusion, in my opinion, IDA is legally obligated to pay the full bond amount as required under Contracts Amendment Act as in Section 5.8. This law is important to ensure the government is fully reimbursed if someone were to fail their service obligation. Now, what are the advices to IDA? First of all, a legal challenge in court is highly unlikely to succeed, as seen in the case of Lee Ming Chong. So, what should IDA do? IDA should instead attempt to negotiate an installment payment plan or settle with MOH rather through litigation. Whereas the advice to the Ministry of Health, of course, the government is on very strong ground.
Assalamualaikum and good afternoon, Madam Nora. For this part of presentation, I will be explaining Situation 5, which focus on the issue of offer, counter-offer, and whether a valid contract was formed. This situation involves two parties, Laila and Aida, and the dispute is about whether their communication resulted in a binding agreement. So before we going into the law, I will briefly explain the material facts of the situation. So in this case, Laila offered to sell her house to Aida for RM 500,000. Aida replied by offering 450,000, which is a lower price. Laila rejected this offer. A few days later, Aida wrote again saying, "I agree to buy at RM 500,000 ringgit." However, Laila refused and claimed that the original offer was no longer valid. So based on these facts, several legal issues arise. The issues, as we can see here in the issues, first, whether Laila's RM 500,000 statement was a valid offer. Second, whether Aida's RM 450,000 reply amounted to a counter offer. And the third one, whether the counter offer terminated the original offer. And the fourth, whether Aida's later acceptance could revive the original offer. And finally, whether a binding contract was formed between the parties. So to answer these issues, we now move to the relevant law. Under Section 2, Subsection A of the Contract Act 1950, a proposal is made when one person signifies to another his willingness to do something with a view to obtaining the assent of that other. Under Section 2, Subsection B, when the person to whom the proposal is made signifies his accent, the proposal becomes an acceptance. And also, another section that we can use is under Section 7, Subsection A, an acceptance must be absolute and unqualified. This principle is clearly illustrated in the case of Hyde against Ranch, 1840, where the court held that a counter offer destroys the original offer and it can no longer be accepted. The principle was also applied in Malaysia in the case of Malayan Flour Mills against Sui Enchi 1997 MLJ 763, where the court confirmed that a counter offer terminates the original offer. Another relevant case that can be related, which is the case of Ramanathan Chettiar against Garnison 1976, second 2 MLJ 113, where the court held that an acceptance must correspond exactly with the offer, otherwise no contract is formed. Now we move to the application. Laila's statement offering to sell the house for RM 500,000 was a valid offer under Section 2, Subsection A. However, when Aida replied offering RM 450,000, this was not an acceptance but a counter offer because it did not mirror the original terms. According to the case of Hyde against Ranch, this counter offer terminated Laila's original offer. Therefore, when Aida later attempted to accept the RM 500,000 price, there was no longer any existing offer to accept. Since the original offer had already been destroyed, Ida later acceptance could not revive it. As a result, there was no meeting of minds and no valid acceptance under section 7 subsection A. Based on this application, I will conclude my part. In conclusion, now we move to the conclusion. In conclusion, no valid contract was formed between Laila and Ida. But Ida's RM 450,000 reply amounted to a counter offer which terminated the original offer, which is RM 500,000. Her later attempt to accept the original price was legally ineffective. Therefore, Laila is not legally obliged to sell the house, and both parties would need to enter a fresh agreement if they still intend to proceed. That concludes my part for Situation 5. Thank you, Madam Nora, and I will now pass the presentation to the next speaker. Thank you.
Now, finally, we come to the conclusion. Now, ultimately, this scenario highlights that while contract law protects those who perform specific conditions of an offer, it also enforces strict statutory obligations and respect the sanctity of domestic boundaries. Now, let's have a cursory look on all the five situations. In the first issue, Cepat Sehat is liable. Because why? Because the bank deposit proved its intention. Now, in the second issue, the couple cannot sue directly due to the lack of privity. But Rahman can, because Rahman has privity. He can sue the state for that. In the third issue, Ida's claim against her mother fails, because the law presumes no legal intent in family support. In the fourth situation, Ida must pay the full MOH bond. Statutory law overrides her penalty argument. In the last issue, there is no valid house sale contract because the counteroffer effectively destroyed the original price. So, our final advice and solutions to the parties is as follows. For Ida, she should pursue the claim against Sehat's neighborhood to recover her medical reward. Now, however, she should try to avoid any sort of litigation against her mother or Lila because it is not going to work. In the case of MOH, not only she should prevent any sort of litigation, she should directly negotiate an installment plan with MOH. Now, for the third parties, Rahman should step in to sue Johan's estate on behalf of the couple to bypass the issue of privity, because Rahman is a direct party to that contract, whereas the couple aren't. So that concludes our project for contract law. We thank you for your consideration. Thank you.